Welcome to Bloomberg Law. I'm Emily Pacchia. In June, Alabama Governor Robert Bentley signed an aggressive immigration law. The law took effect in September, and the federal government quickly sued to block its enforcement. Joining me now to discuss is Careen Shannon from the law firm Fragomen. She's also an adjunct professor of immigration law at Cardozo Law School. We're also joined by Bloomberg Law legal analyst Emily Pataki. Welcome. Thanks so much for coming in, guys.
Thank you.
So, Careen, this is a law that I would say is very aggressive in its posture. Some have compared it to the recently passed immigration law in Arizona, which the federal government also challenged. Is it fair to compare these laws? And if so, are we going to see more of them in other states across the country?
I think it's fair to compare them. I think, in fact, that the Arizona law inspired the Alabama law quite directly. In some places, I think it's almost verbatim the same as the Arizona law. And other states have already jumped on this bandwagon. We have similar laws in Georgia and South Carolina, for example.
So we're seeing the beginning of a trend.
I think we are.
Emily, we've seen a lot of chatter in the media and blogosphere about how this law has impacted the lives of people living in Alabama, undocumented immigrants. Have the comments you've seen specifically about the contracting and transaction provisions, are they valid criticism? What's myth and what's reality here?
Well, I think there's still a lot of confusion because the case is being litigated in the 11th Circuit right now, but it's fair to say that this is a crisis throughout the state, that local agencies are not sure how to interpret the business transaction provision of this law.
And when we talk about those provisions, water companies providing service to houses that have undocumented...
Power companies, local municipal spaces that, that people might want to use. What the provision says is that it's unlawful for illegal aliens to conduct business transactions or attempt to conduct business transactions with the state or any of the state's subdivisions.
That seems like an unworkable dynamic. I mean, who has the burden of proving who's who in this situation? It just doesn't seem like this works.
It is unworkable. And in fact, I mean, there is a provision in the law that says when we're talking about law enforcement checking on people's immigration status, that they are not supposed to independently make that determination. They need to check with the federal government, with the appropriate office within the federal government that has the information to make that determination. A power company, a school district, they should not be in the business of determining immigration status.
So if we have a law that's unworkable, we'll get to the fact of whether or not it's actually legal. But if it's unworkable, then what? What happens to laws like this?
I think it doesn't even matter, and I think that the legislature that enacted this law didn't really care on some level whether it was workable, because that's not really what it's about. There's always the chance that it will get to the Supreme Court and be overturned in whole or in part. But the real purpose of this law and the Arizona law and the other copycat laws like that is what they called in Arizona enforcement through attrition. It's a way of scaring people, scaring immigrants within the borders of the state and hoping that they will leave. And in fact, we're seeing in Alabama that that's already happening.
Okay. Well, let's get to whether this law is legal. Turning to the litigation, on October 14th, Federal District Judge Sharon Blackburn allowed much of the controversial immigration law to stand, but also knocked out some of the provisions. Emily, in your opinion, did she get it right?
Well, the law is incredibly extensive. There are over 30 sections, and one of the provisions that she actually did not enjoin was the one dealing with school students. And so, as is the popular story right now, the schools were directed through the law to request birth certificates or the equivalent of for newly enrolled students. She did not enjoin this provision. However, the 11th Circuit temporarily enjoined it, and so that's one of the hot issues right now. We're waiting to see what the 11th Circuit will do with that in the long term.
Careen, what do you think? Did she get this right?
I think she got this right. I was surprised, in fact, at the extent to which she enjoined the most egregious parts of the law. The other section that she did not enjoin, that the 11th Circuit enjoined, was the one that makes it a misdemeanor to fail to carry immigration papers on your person. That's already in the federal law that you're required to do that, but the federal government has specifically determined that we should not criminalize the failure to carry papers. So that's an issue where I think the state is overreaching.
Prospects for appeal. Is this case going to make it to the Supreme Court? And if so, how are they going to attack it?
Oh, I think it absolutely is on its way to the Supreme Court, along with the Arizona law.
Right. I think the Arizona law, everyone is watching and expecting that the Supreme Court will address these issues, and those, that opinion will speak to other states as well.
So Arizona makes it first? Is that what you're saying? The Arizona law will go to the Supreme Court first?
It may be on the docket within the next
How do we expect the judges to line up? Is there any guidance on this?
Well, the only guidance we have is the decision that the Supreme Court already handed down on the earlier Arizona immigration law, the Legal Arizona Workers Act, which was a much narrower law. It was about requiring employers to use the federal E-Verify system to verify the employment eligibility of their workers, and punishing them for either failing to use E-Verify or for knowingly employing undocumented immigrants by taking away their business license. And the Supreme Court upheld that law, reversing the Ninth Circuit, by focusing on a very narrow provision within the Immigration and Nationality Act. Mm-hmm. The Arizona enforcement law and the Alabama law that we're talking about today is much broader. So I think, although we have a bit of a roadmap from the Supreme Court, in that they left the door open on certain of the preemption issues, it's a little bit difficult to say how exactly they'll come down.
What do we feel in terms of timing? How long is it going to take before this gets to the Supreme Court?
It could be within the next year. Mm-hmm. In terms of timing with the 11th Circuit, the appellate briefs are due within a couple of weeks, and then they'll have oral arguments, and we'll see what they say in Alabama.
We'll certainly be paying attention to this process as it unfolds. I'm struck with a sense of wonderment as to what this means for the Alabama economy. We were talking before that undocumented individuals in Alabama, I think they're small numbers. There's a stark difference between the situation that Arizona faces as a border state. Alabama doesn't quite have the same picture going forward. What is happening to the Alabama economy in light of this law being passed?
I think Alabama is going to see a hit on their economy. It's true that, unlike the so-called border states, the percentage of the population in Alabama that is foreign-born or that's undocumented is small. Focusing on the Latino population in particular, only 4% of the approximately 5 million people living in Alabama are of Latino origin, although that seems to be the focus of the attention is on that population. I think it's clear Arizona took a hit. They lost a lot of tourism, a lot of convention business. As a true border state, they lost a lot of cross-border shopping and tourism.
I would imagine this hits the tax rolls, too.
The last I heard, the unemployment rate in Alabama was 10%, and a lot of the legislators and the governor said that this is actually a jobs bill in some regards because it's opening up jobs for American citizens. The irony of that is when the law was passed in June and the subsequent months, there's been a lot of migration. Migrant workers, children, families have left Alabama, leaving farmers and factories without workers. And there have been definite issues with crops rotting in the fields, factories kind of sitting idle while workers are needed for these roles.
Right. I've seen stories about how they're turning to local prisons to help make up for some of the labor shortfall.
Which is very ironic because this statute creates so many new crimes.
Right.
And so finding prisoners to do the field work.
This is a messy situation. It leaves us at a point where we have to wonder, how is immigration going to be handled in this country? Is this something that should fall on states to come up with their own laws, or is this something that begs federal guidance?
It shouldn't fall on states, and it does beg federal guidance. And of course, that's a lot of the impetus behind these state laws, is that there's this sense that the federal government has not done its job, has not enacted any kind of comprehensive immigration reform. And quite frankly, there's really no prospect of any comprehensive immigration reform in the near future. So it's understandable that states want to step in, but it's completely unworkable. We can't have a patchwork of 50 different immigration laws across the country, or more than 50, because counties and municipalities in some cases are enacting their own immigration ordinances. Immigration needs to be a federal issue. It is a federal issue under the Constitution. I think that most of this law should be preempted, and time will tell how the Supreme Court rules.
Emily, how do you see this playing out?
Well, to your point, I think it's also difficult to imagine municipal police officers, municipal law enforcement interpreting very vast statutes such as these, but not having training in immigration. And so one of the effects of the Arizona immigration law was that a lot of the law enforcement did receive a ton of new training to understand these reasonable suspicion issues to avoid racial profiling. But at the same time, it's a huge undertaking for a state as its own sovereign to try and enforce national immigration laws when they don't really have the resources.
Right, it puts all kinds of economic stress on local and state governments. That said, what is the federal government to do? I mean, it seems legislating anything in this environment is so difficult.
Well,
What's the way forward on this?
What they are doing right now is appealing this in Alabama. They've appealed it in Arizona. They've also appealed it in South Carolina. And so they're very active by way of the Justice Department. But we have to look at Congress and say, where is comprehensive immigration reform? Who's introducing it? Is it viable? How will E-Verify be expanded? And those issues remain to be seen.
Tough times. Careen Shannon from Fragomen and Emily Pataki from Bloomberg Law. Thanks so much for coming in.
Thank you.
Thank you.
If you'd like to learn more about the cases and issues we just discussed, go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Emily Pacchia. Thanks for watching.